think that's the point, is to limit the amount that CEQA can be used as a roadblock to development, which is how it's unfortunately been used in the recent years as a tool to block development.
But I also know that hot button items come up. If you're not careful, you could have friends of whatever coming after you for a rare plant that might be on a hill somewhere half a mile away. What things should they be looking for from an air quality perspective?
If you're showing an impact related to increased health risks and premature cancer and deaths, that's really hard for a lead agency to approve despite those impacts. Right?
Where do you see the most opposition?
The controversy of a project is directly proportional to how close homes are to that project site.
Have you had any that have gone to litigation for an extended period of time and really put a lot of burden on the developer?
We have had a few projects over the years challenged in court, and knock on wood, most of, like 90% of them have been upheld by the court.
Where you see the CEQA analysis going in the future?
Every time they try to go and streamline and fix CEQA at the state level, it ends up being one more thing that we have to do and more documentation that's required, because ultimately it ends up getting sued.
There has been this litigation game that has been increasing over the last couple of decades. Welcome, everybody. I'm here today with Rod Stinson, who is a planning director over at Raney Planning and Management. And Raney specifically focuses on preparing CEQA and NEPA documentation for cities and counties associated with land development projects. And in California, more than likely, they're working for the local agency rather than the developer, because typically local agencies want to see some separation from the CEQA analysis, which is supposed to be focused on whether or not the project has impacts from the applicant, who is the proponent for the project. And you can imagine, I write CEQA documents all the time, but typically they're the highest level we usually get is an ISMND. Rod, you get into EIRs and EISs. It's just, when you start getting to that elevated level of political opposition, it's important to make sure that everybody understands that there isn't crossover there and people aren't cooking the books, essentially.
Right. And I guess just as a brief introduction, Rod Stinson, Vice President at Raney Planning and Management. We've been around in the Sacramento area for 25 years, and we're a local small business and still locally owned. I've been with the company for 20 years now, and basically kind of running the CEQA department. We also do contract planning and air quality technical analyses. The rest of the technical work, though, we usually will sub out, and we'll include those as attachments to our environmental impact reports. And then just to touch on, Chris, what you were mentioning about how the process works and the interaction with the applicant, the local lead agency, jurisdiction, and public perception. We don't come into the process. We're not hired by the agency until an application is submitted, and that application submittal essentially kicks off and triggers the CEQA process if there's a project under CEQA, if there's a discretionary action. And so, you, Chris, are usually on that front end where you're working with the developer and landowner to develop what their application would look like, get it set up for a smooth process through the environmental review. And then at that time, it gets pitched over to us to conduct that independent third-party objective review of the environmental impacts that then get presented to the lead agency, city, county, decision makers to ultimately make a decision on the project. I would note, though, that CEQA does allow for the developer to prepare the CEQA document, and that's accounted through a process at the end where the city as the lead agency or the county as the lead agency has to make certain findings, and they do adopt that CEQA document as their own independent judgment at that hearing phase. So it's allowed, but there's a public perception issue, which is why it's typically kind of tried to be kept separate in the process. But ultimately, throughout that whole process, everyone's kind of rowing in the same direction. Everybody wants to have a defensible environmental document that can be upheld in court should it be sued at the end. So everyone's pretty conservative in that way usually.
Yeah, yeah. Well, speaking of the litigation part at the end, that's usually what developers are most concerned about when it comes to EIRs. The recent legislation that was just signed into law yesterday, I guess it's not really law yet, but would limit the period for any sort of a lawsuit to 270 days. The court would have to make a decision within that time frame. What do you think that's going to do with, say, some of the documents or projects that you've worked on so far? Have you had any that have gone to litigation for an extended period of time and really put a lot of burden on the developer? And how do you think that this change would help?
Yeah, it would certainly streamline it. I think that's the point, is to kind of limit the amount that CEQA can be used as a roadblock to development, which is how it's unfortunately been used in the recent years as a tool to block development. So yeah, kind of limiting the amount of time that can be that a case can sit in court would definitely address that issue. We have had a few projects over the years be challenged in court, and knock on wood, most of like 90% of them have been upheld by the court, and we haven't had to go back and do anything. But that process, right, takes forever because there's appeals and all of the I'm not a lawyer, so all of the lawyery things that have to happen once we're out of the picture, it just takes a long time before any decision is made, and then the project can actually move forward.
How much emphasis do you put on making sure that you got a thorough document? I know that you guys do a thorough job, but how much back and forth do you typically go through with the city or the county, or even through correspondence, even if it's indirect, with the developer, on making sure that your analysis is thorough, but it doesn't necessarily include extra research, analysis?
Yeah, and I think touching on that is sort of where Raney Planning and Management seems to stand out from some of the bigger firms, where we try not to just do a dissertation on every project and do all of this research and study that you don't get a value out of in the end. It's tangential to the CEQA process and the analysis, but not required. So we try to be as efficient with our time and our analyses as possible. And so, what we'll do typically is start with a solid project description, right? That's the most important thing. That would usually get routed back to the applicant team to make sure we're characterizing the project properly and everybody is working on the same page with what the project is. And then that gets, essentially analyzed throughout all of the different topics. If we have a project that is super controversial and we know that we're going to get challenged, then we'll work closely with the lead agency, and even, like the city attorney or county council will be heavily involved and coordinated with their attorneys on reviewing our work. If we get to a point in an analysis where, we could go one way or the other, depending on how conservative that local jurisdiction wants to be, then we'll pick up the phone or we'll reach out and have a meeting, and we'll really kind of dial in how bulletproof they're wanting a document to be, because ultimately anybody can sue on anything, really, right? So you're never going to be fully bulletproof, but the CEQA process is such that it's intended to kind of tease out some of those hot topic areas that people will have concern with, and then at the end, any kind of lawsuit needed to have been involved through the administrative process, so they couldn't be quiet through the whole environmental review process and then at the end come in and sue. They have to have been participating. So at the beginning of the CEQA process, there's a notice of preparation and a scoping meeting where we're soliciting comments on what the scope of the EIR should be. At that time, the intent is to kind of get all of those topics and issues out up front so that then we can analyze them in the EIR. So hopefully there isn't any surprises there, but ultimately anybody can sue on any part of any comments on the draft EIR and then the final and that kind of thing. So
Where do you see the most opposition?
you mean on environmental topics or types of projects?
Well, maybe both, but I mean, you've got a modicum of projects that are coming in the door. You probably already know right up front which ones are going to be controversial or not. You already mentioned that.
Yeah.
What is typically a controversial item that you think or know would get to litigation at some point? What are the typical ones? Because as a private, as a consultant that typically deals with private developers, I know where the trigger points are, and we emphasize biology and wetlands, and other things like possible cultural resources extensively. It just kind of depends on the particular project and what the site characteristics are. But I also know that hot button items come up. If you're not careful, you could have friends of whatever coming after you for a rare plant that might be on a hill somewhere half a mile away, or other things like that maybe kind of out of left field sometimes.
Right. Yeah. So usually the more controversial projects is directly proportional. The controversy of a project is directly proportional to how close homes are to that project site, right? So if you've got neighbors right up to it, no matter what that project is, you're going to get some comments and some potential pushback. If that project is an oil refinery, right, you're really gonna hear it. But any kind of project, and some that change the general plan designation or require annexation or some sort of development or plan that wasn't necessarily in the long range planning of that jurisdiction, you'll usually get some people coming out and that's when kind of biology comes up too, where it's like, we haven't planned this for development. It was supposed to be open space. We've got some potential species out there or wetlands, and you'll get friends of those species come out and make comments, right? So there's that. Air quality is a hot button issue, depending on the project, with toxic air contaminants and health risk assessments that we would need to do, depending on the type of project. There's been a lot of warehouse development the last few years, and if there's distribution centers, they have high emissions of diesel particulate matter, and so the potential increase in cancer risk is one of those hot button issues. And if you've got that next to an existing neighborhood, we definitely need to analyze it. But if you're showing an impact related to increased health risks and premature cancer and deaths, that's really hard for a lead agency to approve, despite those impacts, right? So those types of analyses become really important, and knowing, so for developers to know ahead of time if there's going to be a potential issue and they need to adjust their project before submitting it, that might be something that folks watching this might want to consider if they're developers, to include in part of their constraints analysis and due diligence when they're looking at projects.
Do you see that kind of pushback on air quality with residential housing being proposed next to residential housing?
Residential next to residential, not so much on the operational side, but construction.
Construction.
Look at construction health risk assessments. But all of that, and this might get into some of the unknowns of the political environment today. But all of those emissions over time, in theory, get better. There's less emissions. The engines get more efficient. Construction equipment, the air district gets more and more stringent, and tier 3, tier 4 engines with those heavy duty off road vehicles become more integrated in vehicle fleets and equipment fleets that construction crews use. So those emissions over time should be going down, kind of with a aim toward going all electric, which is pretty difficult, right? At least as things stand right now, right there just isn't the technology or the demand or the infrastructure to support
it's
that yet.
important, yeah. And also now you've got a federal administration that's pushing back, including the Senate getting involved. So
right, yeah. So state of California had certain goals and regulations related to sale of all electric passenger vehicles, as an example, but there was also off-road diesel engines with a target to go all electric. And so all of that now is kind of up in the air. So for our analyses now, there isn't really the definitive assumptions that we could make just a few years ago because it was in the regs. Now we have to add a little bit of some wishy-washy language that this may or may not be the case, and here's the best assumption we can make at this time, and it's the best data we have to support our analysis, and we're providing substantial evidence to support whatever conclusion we come to. That's ultimately kind of what it comes down to under CEQA.
Okay. Are you starting to see more of a conflict between federal and state law?
Not yet. Not yet. Right now we're still kind of relying on California laws. We're enacting a California Environmental Quality Act law, so it applies to the state. It's nice when they jive,
Yeah,
and are kind of rowing in the same direction, but we just sort of do the best we can as things are in a state of flux, and then see where it all lands, and then we can figure out what to do from there. But
so if a developer who's coming into the Central Valley, Sacramento region, that's where we are at least, and they're looking to put a development on the ground, what things should they be looking for from an air quality perspective? And then maybe I can address a lot of the CEQA stuff, but you guys are obviously the experts in the room when it comes to air quality. What should they be looking for right off the bat that would, maybe dissuade them? It's because a lot of times you're starting with looking at a piece of property, but you don't really know whether or not it's going to work or not, right? You got to start doing some analysis on it. And our analysis approach really starts with site characteristics, looking at biology and wetlands, looking at land use. But, for something like air quality, it's a little bit more nebulous. How do you really know what it is that you're going to even trigger until you start crunching numbers on, construction and operations?
yeah, there are so many variables. It'll depend on the size of your project. For the construction, potential emissions related to construction comes down to size of the project and extent of the grading activities. Most of the harmful emissions occur during that initial mass grading and fine site grading phase. And then as far as operation goes, it's kind of the type of project. If it's something like residential, you really don't have a lot of problematic emissions other than your mobile source emissions and your area source emissions that are pretty standard for residential development. And those are mass emissions that aren't concentration based, so it doesn't necessarily matter what's all around you. But if that project is huge, you'll be triggering the thresholds of significance from the local air district, and be needing to think about mitigation for operational emissions. Mostly depends on size, though. Most air districts have a screening table of when a project is big enough to potentially trigger an impact. So sometimes you can look at that and see where a project sits and know generally, based on the size, whether there's a potential issue. And then if you've got a distribution center or something that has high diesel particulate trips, diesel particulate emission sources, usually truck trips, but it could be some on-site, operations if it's a cannery or depending on what the project is. Then you'd be wanting to look at where's the nearest sensitive receptors. So residents, schools, daycares, hospitals, nursing homes, that kind of thing. If there's one of those right next door, you might want to rethink about what the land use you're proposing or where you're siting it and on the site, right? So,
So
those are kind of the big things.
yeah, well, that makes a lot of sense from a project level, but when you start getting into like more of a programmatic level, because if some of these residential projects can be 3,000 acres, and when you start adding them all up, I would imagine that, and I know from reading air quality management district regulations that they do have thresholds there, so it seems a little bit arbitrary sometimes about how they apply or how they come up with a threshold for an area, other than it might make somebody sick. Well, okay, but then you take that threshold and then how do you apply that over an entire region where you're proposing development? So like yesterday's CEQA reform, for example, is likely going to add a significant amount of housing to California, right? In areas that are already kind of urbanized, but that's going to be, cumulatively, that could be a big increase in the even like daily vehicle trips, for example, because I know that's how you calculate out your air quality emissions when you're operating. So if you've got a residential subdivision and you've got 2 vehicle daily trips for each house, that's only a matter of time that you're going to get to a point where you got enough houses and vehicle daily trips to, to go over the threshold. So, and then it just seems like things just kind of move around. So like, can you kind of talk about that?
Yeah.
What's the effect of it?
Well, the key component of the new legislation is that you still need to be consistent with the general plan and zoning.
Yeah.
And then that means that you're consistent with the general plan and general plan EIR. And then that also means that then the regional planning that has occurred that relied on those local cities' general plan projections for development are still consistent. The thresholds of significance are developed from a basin-wide standpoint. So sometimes there's air districts that are completely within one air basin, but most of the time the air basins are huge, right? So there's a couple of different air districts and air quality management districts within one air basin, and then they'll coordinate to come up with their own projections for basin-wide emissions assumptions and what is needed to reduce those emissions. And then as a local air district, they'll come up with their own thresholds of significance based on the projected development within their air basin or within their air district. And then it all kind of comes back to the ambient air quality standards that are monitored, and there's federal and state. And if you're in a non-attainment basin, those local air districts need to come up with a state implementation plan that comes up with a plan as to how you will get to attainment at a certain point in the future. And so there's all the studies and calculations that are done to identify, okay, if all new development is held to this pounds per day, threshold, then that's less than significant. With eventually going down this path, we will meet attainment for this air quality pollutant. And so that has worked throughout the state, right? Like there are air basins that are now in attainment that weren't before. LA is the typical example in the 70s when it was like all smog inundated, and then the Clean Air Act was adopted, and then the air districts kind of went through this process to reduce emissions. It's worked. It's not like that there anymore. So not that the air quality is the greatest, but
Better than the 70s.
it's better. It's better than it was.
What do you think the number one mistake that developers make with air quality
With their air quality
analysis?
Ones that, so I can speak to the ones that we receive and then peer review and provide comments. Typically, the most common mistake is in their assumptions in the model, where you're not covering offsite improvements. So you've got a project with the boundaries, but if you have to extend a water line, a mile to serve water to this project site, that's part of the proposed project under CEQA. And so you have to analyze the construction emissions of that.
Yep.
It becomes part of the project. So sometimes that is missing from their analyses. Probably the hardest thing right now for the development community is straying away from the air quality discussions we're talking about and moving into the greenhouse gas emissions and looking at climate action plan consistency, if a local jurisdiction even has a climate action plan. But the state and those plans are going toward a carbon neutrality goal for 2045 and 2050, to where, what does that even mean? Your project is going to have emissions. So how do we, through an analysis now in 2025, show that in, 20, 25 years,
2040,
you're going to be net zero. So it essentially means that the new projects today that are in those jurisdictions that have that as a threshold and a requirement, that they either have to be some level of a energy producer and have enough solar to have their own microgrid that supplies their own electricity independent of the PG&E or something, or they're purchasing carbon offsets and just throwing money at it, basically. And so that begs a question too of, are there cap and trade programs to even purchase offsets for enough to offset some of these bigger projects? That's sort of a question mark.
Yeah. Okay. Well, that's a big topic right there. And I mean, who knows if climate change even exists, right? So,
yeah. Well, we're in the lucky position to where we don't have to make a determination of the existence or not. We're just implementing the statutes.
Right. So, I guess if you can maybe we could switch gears here a little bit for the last couple of minutes and talk about where you see CEQA analysis going in the future. I know we just saw Gavin Newsom sign CEQA reform legislation yesterday, which I think is going to have some significant effects on how projects are handled in the future, just because of raising some of those thresholds. But there has been this litigation game that has been increasing over the last couple of decades. California has a huge housing shortage, and kind of bleeding lots of people dry because they can't find affordable housing. So where do you see CEQA, at least from your practice of your projects coming in the door? I know Sacramento is kind of booming right now with a lot of housing development. That's probably, it's going to last a while because we have a lot of land potentially to develop. But at some point, how do you see that changing over time, the CEQA process?
Yeah. Well, so in California in particular, which is the reason why this legislature or this new bill happened anyway, is that we do have a shortage of housing in the state, And so there's just this demand for housing, and we're trying to fill it. That doesn't seem to be going away anytime soon, right? Even with the adoption of, right, with Newsom signing this bill, we're going to trying to take a bite out of that demand and provide some additional housing, but it's going to be there for a while. And then as far as CEQA goes, for all of our other projects that are not residential, I don't know that anything's going to necessarily change for us. So for residential projects that are consistent with general plan and zoning and qualify for being builder's remedy, I see a lot more exemptions being sought. But what that means with all of the litigation that then happens is that those exemptions will likely be asked to prepare a memo in support of this exemption, showing that it meets all of the criteria. And, there's still some environmental topics in there of, historical impacts, for example. There's still some things that you need to check box and show that this project, yeah. So a lot of times we'll be asked to prepare a memo in support of an exemption. There's a fairly popular CEQA streamlining event exemption that's used now. 15183 section of CEQA guidelines allows for no further CEQA to be completed if a project is consistent with the general plan. And then you just have to go through an exercise that shows that the project's not, there's nothing unique or peculiar about the project or the site that would mean that it's beyond what was analyzed or anticipated in the general plan EIR process. So that's a streamlining exemption, but we end up preparing a big, thick CEQA analysis that goes in support of it. And it ends up actually being sometimes more work than an initial study would have been.
Yeah, right. Well, at least
it gives you more defensibility, right? That's why they want to do it, but it ends up being more work for us. So every time they try to go and streamline and fix CEQA at the state level, it ends up being one more thing that we have to do and more documentation that's required, because ultimately it ends up getting sued. So even though I think there's going to be more exemptions being pursued, I think we're still going to be asked to do some level of environmental review to support those exemptions, and include into the record so that they have something that's defensible should they get challenged in court.
The biggest boon that I can see right there is that they would not have to go through the public review process. That really just takes so long, and if you get comments back, then you got to go back to the drawing board potentially. So, and then of course there's the litigation risk at the end. So, very good. Well, those are all the questions that I have for you today, and I think this was a really productive conversation. Do you have any final comments that you want to leave with us?
No, I mean, we started the conversation talking about how, we typically would be under contract with a city or a county and kind of come in at that phase. That doesn't mean we don't talk to developers and are kind of dialed in as far as what projects are coming, so that we can help, similar to what you do, just give a little pointers on, your project might be too close, so and welcome calls like that, to talk through a project and give us some advice. You and I can work together on that if there's a controversial project. And then it kind of gives us a foot in the door potentially if it's in a jurisdiction that we're already working in. We can gives a kind of a pipeline to another job, and we can have a head start on it and be efficient to get the work done.
I think, you and I have had some experiences with that recently, and I think it works pretty well. For me, it's always helpful to have an expert like you around that I can ask some CEQA specific questions for, because as much as we write CEQA documents, I'm not usually involved with, especially EIRs. I'm more on the private side, so it's helpful to kind of like have some connection point to the other side of the aisle, if you will, or at least to compare notes. That's been really helpful. And then of course you and I have had some good experiences working on projects where I can kind of help facilitate the approval process there, for you guys to get approved for it. So yeah, that works well. Yeah, no, I think that your expertise is very valuable up front. And I think that, similar to mine, it's as much as developers may not want to hear it, it's super important. This is really the nuts and the bolts of how to get a project approved, because it's one thing to draw a pretty house. It's quite another to go through the environmental impact part, So,
Exactly. Yep. Yep. And the public outreach portion too. I've seen a lot of projects fail in that. And then when they get to the hearing, it all falls apart. There's a lot of people coming out in protest of the project. And then the city council asks, how many public workshops did you have to talk to your neighbors? And we didn't have any. So it's like, well, then go do that and come back to me, So, yeah,
how long
it
you guys
takes a
do
team
that kind of stuff, just out of curiosity.
to do what? Sorry.
The public outreach stuff on larger projects.
Yeah. So our policy is that because we are an objective third party that's providing a fact-based document to the city for them to adopt as their own and make a decision based off of, we don't advocate one way or another for or against a project. So that's kind of where we have to walk a fine line, where we are being objective. So in that case, we don't necessarily do public workshops and outreach to garner support for a project. We try to stray away from that to where we're keeping ourselves somewhat isolated from those types of processes. But for what we were talking about, kind of teaming up to have a little bit of a consultation discussion early on, then we step away if we're going to write the EIR, and then a firm like yours, you would help them through the rest of that, be the project proponent and working them through the process, where we wouldn't be necessarily involved so much at that point.
That makes sense.
Yeah.
Keeping the arm's length. All right.
Exactly.
Okay, well, great. Rod, really nice to have you on with us today, and I appreciate you taking the time and sharing your expertise. So
yeah, no problem. And if any of the listeners out there in the Sacramento area want a good band, just let us know, because
what band would that be again?
It'll be the Rod Stinson Band. You should check us out. RodStinsonBand.com.
Yeah. All right, Rod. Well, thanks a lot. You take care.
All right, man.
Yeah.